So, motion for leave to amend a complaint. So, after that order, whatever that is, then there is this situation where there was alleged to be a swap when it came to the filing. See, they alleged that she misfiled the response under the wrong case. That wasn't her recollection. Her concern was that what happened was she'd done them overnight, and when she went to submit them online, somebody swapped them because they had already used the two cases that were of concern in swap activity, and they wanted to make it look like she had made the procedural error so that if something came up later in their automatic referral process, it would look like it fell on her. What does this say? The distinction between pro se representation and acknowledgement of one's capacity to advocate on behalf of another person pursuing exercise of rights to due process under the terms to which Charity Colleen Krause has been subjected is a material difference in regards to comportment and behavior that can be expected of all involved in the proceeding. Later, Charity Colleen Krause argued in her original leave to file motion for a new trial that one of the major points of contention was the use of her legal filings as derivative actions in regards to other proceedings while she was personally denied any due process. Later, in the United States District Court for the Northern District of Texas alone, Charity Colleen Krause has tracked how her efforts were disabused to merely continue perpetuating derivative efforts connected to legal proceedings and financial arrangements aimed to benefit others in denial of her rights to due process. Later, Judge Irma Carrillo Ramirez was again permitted to provide a filing of record in consideration of Charity Colleen Krause's case is in violation of the appropriate local civil rules as well as violation of the federal rules of civil procedure, compels consideration as to whether or not such an action was engaged with malicious intent. Later, this calls into question whether Judge Irma Carrillo Ramirez was actually addressing the interests of the cases at hand as a judge or performing in a representative manner in regards to her colleagues, Judge Renee Harris Tolliver and Judge Ed Kincaid. If it was merely a matter of automation, and Judge Irma Carrillo Ramirez neglected to consider the case on its merits, then this provides further proof of the need to reconsider the treatment of cases by pro se litigants and their assignment to a magistrate judge, especially in violation of the rights to consent accorded to one under the law. No prior disclosure of Special Order 3-251, it's written here as 521, had been provided previously. Would a recognized attorney be required to submit oneself against his or her consent to a specific ascribement per an undisclosed special order? Or would it violate Rule J of Dondi Properties Corp. Versus Commerce Savings and Loans Association, 121 FRD 284, Northern District, Texas, 1988, in bank? Charity Colleen Krause challenges the recurrent pattern of racketeering activity that is prevalent in the proceedings thus far in consideration of disclosure of potential conflicts of interest and their capacity to be otherwise accommodated. Such actions are ostensibly the sort of cooperation that professional legal representatives are held to so as to mitigate against allegations of engaging unprofessional or illegal conduct in performance of their duties. The fact that such cooperation is not accorded to a person forced to represent themselves pro se is a material factor in this proceeding. What's this note say? C-28, Section 455. Specific consideration of an effort to invoke F needs to consider that the request was for criminal consideration, not civil, and disqualification based on fiduciary considerations would also be considered in accordance with culpability in the crimes being sought for prosecution. Later, the concerns raised herein and in consideration of the other allegations levied in the specific filings that Charity Colleen Krause submitted and that were assigned to Judge Irma Carrillo Ramirez assure that the issue is not in fact moot, but at the core of the arguments presented for consideration in the original leave to file motion for a new trial. If Charity Colleen Krause can be repeatedly denied legal counsel while attempting to exercise her rights to due process, and also to protect herself against efforts to extort her into agreement to cooperate with activities she is cognizant are illegal, then the court at some point has to weigh the profundity of the refusal of those deemed certified to be accounted the privileges and benefits of consideration as a formal member of the bar against the constitutional question of rights to due process being denied without just cause. Later, a good faith effort to engage the judicial branch of government in exercise of due process does not necessarily mean a subjugation of one's rights to the opportunistic gain of members of a bar association. There's a note here. What's she say? Quote, based on the findings and recommendations, the court finds that any appeal of this action would present no arguable merit and would therefore be frivolous. End quote. This is in consideration of the characterization of the appeal as an objection. The specific decision was that it be dismissed without prejudice for lack of jurisdiction. This was what occurred with the original filing for review before an in-bank impaneling of the Texas Supreme Court in exercise of its plenary powers, which is understood to mean that the appropriate jurisdiction is a criminal court. Krauss did request consideration of a case that had federal jurisdiction concerning the role of the federal court in reconciling constitutional errors by the state court, including the state Supreme Court, as well as consideration under a case for RICO charges, understanding that the state of Texas has no civil recourse for a RICO case and that this qualifies for consideration in a criminal court. Further down, if no other means to exercise due process can be accorded to a plaintiff than to have access to representation that is permitted to perform in accordance with a select professional society, then it is requested that for consideration of the specific cases presented, Charity Colleen Krauss be granted the status of a bar member pro hoc vis, attendant with the assistance that would be available to a representative of the law seeking to mount a case for prosecution. And there's the last note here. There's another note. Now, there were two follow-up notes before. What's this say? Harris Tolliver cites a case regarding must dismiss the action, but there are other cases that would have permitted for a referral or removal to another jurisdiction or for a writ of mandamus. Another note. In a request for new trial, there are precedents for consideration of a different district court reviewing the decision of another district court. In the state of Texas, there is specific precedent and even rules of professional conduct regarding trial concerning attorneys outside of their local jurisdiction. Now, I checked this, and actually, at least according to what's available now, it does say that there is a means by which to address professional misconduct or allegations that necessitate consideration of a disciplinary grievance within any competent court, and then once the decision is made, it is to be implemented in the court that is the local court for the individual of concern. Finally, specific regard is made concerning a period of 3 years of consideration in terms of qualification as a member of the local bar association per the rules of the Northern District of Texas U.S. District Court. Eliminating consideration of Eliminating consideration of efforts to file in the Northern District affects consideration of these timelines, as does not accepting consideration of the federal jurisdiction consideration regarding correcting for the errors of the state Supreme Court. In fact, past efforts to contact the Supreme Court of the United States regarding correction of errors concerning lower district courts, as well as the Texas Supreme Court, have been addressed through referral back to a lower district court. This then brings into consideration the refusal of the district court to address matters related to transfer or referral to Court of Appeals or issuance of judicial discretion in terms of referring the court to the appropriate venue, rather than dismissing it without considering the facts of the case or the merits of the arguments regarding the charges. This not only impacts the specific court of concern, but also other courts that require consideration of their surety in connection with the surety associated with other cases, which would be referred to or through that court of consideration. See appeal that was ready on December 4th, 2020, and was updated by March 29th, 2021.